Welcome to Teleforum, a podcast of the Federalist Society's practice groups. I'm Dean Reuter, Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. For exclusive access to live recordings of practice group Teleforum calls, become a Federalist Society member today at fedsoc.org.
Welcome, everyone, to the Federalist Society's Teleforum conference call. As is Friday afternoon, April 23rd, 2021. I hope you're still with us after this busy week of programming. We're grateful for you being here. We've got a Courthouse Steps oral argument teleforum on a case called Minerva Surgical versus Hologic Inc. I'm Nick Marr, Assistant Director of Practice Groups at the Federalist Society. As always, please note that expressions of opinion on our call today are those of our expert. We're very pleased to be joined this afternoon. We're very grateful for his time by Professor Daniel Ortiz. He's Michael J. and Jane R. Horvitz Distinguished Professor of Law, and he's a director of the Supreme Court Litigation Clinic at University of Virginia School of Law, which is where he became involved in this case or aware of this case in the first place. So we're very grateful for Professor Ortiz being here today. And with that, Professor, the floor is yours.
Well, thank you, Nick, and thank all the listeners for coming out so late on a Friday afternoon. I realize the martini hour is nigh, so I'll try to be as clear and concise as I can be. I want to apologize or at least warn you of the perspective I'll be offering here. I can't really speak as an IP expert. It was, in fact, one of my dad's greatest disappointments as an IP lawyer himself that I focused elsewhere. To the extent that I can claim any expertise in the case, it's as a generalist Supreme Court practitioner who participated in the case through the clinic here at UVA. We submitted an amicus brief in support of Hologic, but that's not my job today. My job is different. I'm happy to talk about that brief if you want during the question period. But in my presentation, I want to focus more objectively on the issue in the case and more specifically on the oral argument. So first, the issue. I mean, it's a really classic one, but sort of displaced or located in sort of technical patent law. But the general issue is the extent to which a statutory provision overrides the common law, something that everyone is familiar with from law school. Here, in particular, it's whether 35 U.S.C. Section 282, which says, quote, invalidity shall be a defense in any action involving the validity or infringement of a patent, with the emphasis on the phrase in any action, abrogates the patent doctrine of assignor estoppel, which prevents an assignor from impeaching in district court proceedings the validity of a patent it assigned. Now, for those of you who aren't IP nerds, or maybe even patent nerds in particular, this may seem a very narrow parochial issue, but one acknowledgedly of some importance to patent practice and policy. And I want to argue that actually it turned out that that view is wrong, and show how the oral argument demonstrated as it veered from, say, stare decisis to close parsing of precedent to patent policy, patent meta-policy, and law and economics, that there was a lot more sort of going on in the case, and there are many different perspectives from which to view it. And so I want to show that there's something in this case for everyone, and in fact, that's why my clinic students who did most of the heavy lifting here in our briefing found it so rewarding. It was also a case, I think, as the oral argument showed, where amici, and one in particular, had a big effect in defining the issues and sketching out the lines of analysis for the court. So first, the facts. They're pretty complex, so I'm just going to give you the simplified version of them. I think that's sufficient to understand what's going on. There's a guy, Trakai, an inventor, who assigned his patent rights to a company that was ultimately taken over by Hologic. And then he went off and ultimately founded Minerva and created a device which competed with the one Hologic had patented based on his earlier work. Hologic then sued for infringement, and there was also, and I can talk about it later if you're interested, a parallel inter pares review proceeding going on. I don't want to complicate it too much now. But at the trial, Minerva attacked the validity of the patent in defending against infringement, and Hologic asserted this doctrine of assignor estoppel against it, claiming that since Minerva and Truckeye were in privity, Minerva could not impugn the validity of the patent. Now, the district court held that the doctrine applied and largely found against Minerva. And then on appeal to the Federal Circuit, Judge Stoll found that circuit precedent foreclosed Minerva's argument that Section 282 overrode the common law doctrine. Really interestingly, though, she also wrote a separate individual opinion, noting that the Federal Circuit's approach was somewhat contradictory, since it had held in another case, Arista, that the American Invents Act abrogated the doctrine of assignor estoppel in IPR proceedings. So she called for an en banc review, thinking that what's sauce for the goose should be sauce for the gander, or at least they should be consistent, and noted the worry about the practical inconsistencies. Now, technically, this relevant section of the American Invents Act, 35 U.S.C. Section 311A, is a little bit different. It doesn't use the any proceeding, any action language. It says, quote, a person who is not the owner of a patent may file an IPR. So you could technically argue that one provision could abrogate the doctrine where the other could not, but many people thought that, it should be applied consistently. Now, the parties filed cross petitions for rehearing en banc before the Federal Circuit, and the Federal Circuit denied them both. Minerva then filed a petition for certiorari in the Supreme Court, and Hologic filed a cross petition. And the Supreme Court granted Minerva's and denied Hologic's. Now, in the briefing, Minerva took the position that the statute overrode the common law doctrine. Hologic, of course, took the opposite position. And Minerva then also argued that if the court retained assignor estoppel, it should limit it by requiring express representation and assignee reliance, which in effect would largely assimilate the doctrine to traditional equitable estoppel. So as framed by the parties, it was largely an issue of statutory construction, and in particular whether the statute abrogated the common law. Now, it wasn't actually talked about much directly in these terms, but you could say that the parties' arguments were joined on the canon of statutory construction that statutes in derogation of the common law should be strictly construed, or the canon that Congress is generally presumed to legislate against the background law, and whether those applied or not. And as you would imagine, that kind of inquiry raised a lot of issues like how specific does the statute have to be to override the common law? How settled does the common law have to be? How important does the common law policy have to be? Things like that. Now, the amici actually briefed it somewhat differently. There's most discussion of the United States' brief, which offered an intermediate position. The United States put forward a proposal that the doctrine should be retained but modified in two critical ways. It should apply, in the United States' view, only where there was, quote-unquote, valuable consideration for the assignment, and when the rights assigned were, quote, materially identical to the claims that were being litigated over. And there were other amici which helped shape the argument. I think it's fair to say that they were less important, and we were one of those. Now, the oral argument, as I said before, is really interesting. The court talked about everything that you could imagine pretty much, and the three attorneys did a great job. The most embarrassing moment came at the very end when the Chief Justice tried to end the argument, forgetting that Rob Hochman, who represented Minerva, had not yet had a chance to offer up his rebuttal. It showed a bench that was surprisingly well prepared for what you might have thought was a pretty much technical, down-in-the-weeds issue. And perhaps even more surprisingly, the bench was really engaged. In short, it was a good example of the Supreme Court doing what you hope that it would usually do. Now, they talked about, as I said, from several different perspectives. As the parties, in the discussion of as the parties framed the issue, there was lots of talk about how settled assignor estoppel was, whether the Supreme Court and lower courts had moved away from it or settled it more firmly in a series of cases that found some exceptions with it and abrogated a different doctrine called licensee estoppel. There were questions, particularly from Justice Thomas, about whether other common law doctrines, particularly of claim and issue preclusion, would also be derogated from under the petitioner's theory. And I think, these were all pretty much expected from the briefing, but they were handled well, I thought, by both the attorneys and the justices. More surprisingly, several of the justices raised issues of stare decisis. So, for example, if the law was settled as the respondents claim, they asked, could the court now overrule it, or is that something that Congress had to do? And Justices Alito and Kagan seemed particularly interested in this large background issue. And in the case of some justices, I think maybe Justice Kagan in particular, it seemed that the shadow of stare decisis as a larger doctrine and its potential role in other cases might affect somewhat how the court ends up looking at the case. The Chief Justice asked two questions right off the block, and I think that those questions show the wide range of the inquiry. His first question was one of meta-policy that is taken back to fundamentals. He said, which party's view was more consistent with promoting the progress of science and the useful arts? And this brought up the issue, among other things, of the proper perspective to take in the case, sort of whether it should be ex post or ex ante. Ex post meaning, invalidating bad patents. Bad patents are a bad thing, so the law should strive to invalidate them. The ex ante perspective being more, you have to worry about settling property rights. The second question he asked was very doctrinal specific and practical. He asked Rob Hoffman, who was representing Minerva, how do you feel about the government's approach? Several justices kept coming back to this, focusing on each of the two parts of the government's proposed test. Now, if you remember, the first part was that the assignment had to involve, quote-unquote, valuable consideration. And several justices seemed to be interested in whether employee inventors would be covered, meaning inventors who worked for a corporation rather than inventors who sort of work by themselves. And what was most interesting about that is it seemed that it might cut both ways with different ways with different justices. Justice Gorsuch, for example, thought that it was a good thing that employee inventors not be covered, and sort of mentioned David and Goliath, things like that. And he thought that this applying it to employee inventors might actually impede innovation. And I think, he was largely jogged in that direction by an amicus brief that was submitted, a very good amicus brief that was submitted by a group of law professors. Some other justices, I'm thinking here of particularly the Chief Justice, seem to think, if it is important that employee inventors actually be covered. So we'll see, which way that goes. The other bit of the government's test was that the rights assigned had to be, quote unquote, materially identical to the claims that were later being litigated over. And here there were a lot of questions about how that would work in practice. Whether it would explode litigation, meaning that you'd have to have litigation within litigation about how similar the claims were. Justice Barrett, in particular, asked whether this would involve a battle of the experts. Other justices thought that it was important, maybe, Justice Kagan in particular, and was worried about claims expanding too much beyond what the assignor originally thought. And several were very interested in how much distance there was in practice between Minerva and the government's view. So a lot of questions asked about that. Several justices also asked law and economic questions concerning incentives that would be created by each of the rules. The Chief Justice's initial question, for example, did that. And Justice Alito asked a question about whether Minerva's proposed rule, which would abolish assignor estoppel, could be contracted around. And there were two justices whose thinking or questions surprised me a little, because they were thinking very hard about changed circumstances and how the law would change, and these larger questions of how you handle a doctrine that might be settled when everything around it or some of the things around it have moved. So, for example, Justice Sotomayor asked questions about how this doctrine surrounding assignor estoppel had changed since it was adopted or recognized in the 1920s. And she pointed out that issues that once sounded in claim construction now sounded more in validity, and how that might make that change in doctrinal analysis might make a difference. And Justice Breyer, on the other hand, asked an even larger question, I think, about how changes in employment markets, complexity of inventions, and the nature of invention itself might, since the time of Westinghouse, the case it recognized, where the Supreme Court recognized assignor estoppel, might make a difference. Now, I know the bottom line is what you're interested in. You all want to know whether I think the petitioner or respondents will win. If I can say with great certainty, yes. But joking aside, I think this is a case that's particularly going to be hard to predict the winners or the losers. There's a lot of interest in the United States intermediate position, but on the other hand, there was a lot of really hard questioning about it. And different justices seem to be taking different positions on different parts of it. And it's possible for the court to adopt, I think, one part of it without adopting the other. So they could sort of drop the valuable consideration thing, or at least say that that doesn't mean that employee inventors aren't covered, but adopt the material identical part. They are, technically speaking, logically independent. So I think it's hard. They might adopt the government's proposal, but maybe not in the form that the government actually proposed it. And it looked like to me that Justice Gorsuch was the one who was most interested in abrogating the doctrine. And Justice Alito was the one least interested in abrogating it. And the others were pretty much hard to read. But again, that's just an individual view from someone who's not an IP expert. So, my only advice, bottom line, stay tuned. Can't offer you any more certainty than that. So I think that's a good place to end. If anyone has any kinds of questions, which I might be able to field, I'd be happy to talk.
Okay, great. Let's open the floor for questions now. 1 second here. Dan, actually, it looks like our software platform might be a little bit funky right now.
Okay, I'm happy to stay by or go home for my own martini.
Let's see. Well, you might have already addressed this. What I always like to ask, what was the most surprising part to you? Any people ask questions you didn't expect, things like that?
The most surprising part for me, as I said, was just the Chief Justice forgetting that someone hadn't had their final turn yet, and it's ending the argument. That was, is interesting just in a kind of cute little way. For me, the most unexpected part of the argument was Justice Sotomayor and Justice Breyer's interest in how, in Justice Sotomayor's case, the surrounding doctrine had changed, and how you take that into account in figuring out whether it's appropriate to retain, modify, or abolish a doctrine. That's a kind of very general meta-legal question. And then Justice Breyer's question, I guess, is not so surprising for him, since, he often takes a kind of pragmatic or purposive approach. But, the idea, it was, a real interesting question. The world has changed since 1920 when Chief Justice Taft recognized this doctrine. Inventions are different. Things are much more complex. Employment markets have changed. Just all these things that bear in some way on at least, how the Taft Court might have looked at it originally and how we should look at it now. Those are different. How should that affect our analysis? So I thought, it's not really a quote unquote legal question, but of course it's something that you would think would be of importance to at least some of them.
Great, and we actually do have a question.
So thank you very much for this very interesting piece here. So you mentioned these broad policy questions, particularly the law and economics. I was wondering if you could elaborate on that a little bit, particularly as it pertains to kind of the economic consideration of quote unquote innovation, and how the Chief Justice understood how to think about measuring such a thing, or if they had any sense of what they were talking about when it came to weighing the different Yeah, thank you.
So, what the Chief Justice, the question he was teeing up, or the issue he was teeing up, is an important one in IP and property law generally, which is when you are evaluating any particular doctrine, to what extent is it appropriate to adopt an ex post rather than an ex ante perspective? So as he put it, we want to, bad patents are in some sense a bad thing. And so there is a policy against granting monopoly rights that, shouldn't be granted. And, that's economically harmful, impedes the progress of invention, all of that. Says on the other hand, it's important for property rights to be settled, because if property rights are unsettled, people won't trade property. And that will, to some point, potentially impede the progress of invention. Someone is thinking of making a trade, assigning patent rights. If the assignee believes that those patent rights aren't really settled or less settled than they might be otherwise, presumably the trade is going to be less valuable, kind of thing. So I think what he was doing was trying to say, to what extent should we look at the central patent issue as laid out in the patent clause of the Constitution? Should we look at it ex post, ex ante, and how under each approach, how would things weigh? So it's a very big and really interesting question. I don't think that the lawyers, I don't think, grappled with it at the level that he pitched it out, and they offered more particular responses on a much more focused level from each side. But I think what he was doing up there, what he was doing in throwing out that first question, was basically trying to get to the very bottom of it, and so we have these two with these two conflicting perspectives we could take on it, and each one would seem to point, or was argued among the in the briefs, that each one pointed in a somewhat different direction. And so, what do we do with that? How do we balance it? And so it was wonderful. He was like going to the very bottom of the case, and he didn't use law and economic terms, but the analysis the question he was asking is traditionally seen as one.
I'm right there with you. I guess my question was, as he was trying to quote unquote get to the bottom of it, it seemed to me to also imply some notion of some normative, we'll call it, framework to evaluate what's being done. There was no clean way in which he said, doing it before or after, or weighing these considerations. He didn't give anything that was kind of substantive in that space. He just kind of suggested that the evaluation of the sequencing might have these other policy considerations. Is that what I should take from this?
Well, yeah, no, he was asking for the lawyer's advice on sort of, how we have these two different perspectives, how do they weigh against each other, kind of thing. I don't think he was tipping his hand that one was necessarily more appropriate than the other. But both, as you suggested, were, substantive or normative positions, and, that are just different ways of trying to think about what best promotes the progress of invention.
But then again, he never gives us any intuition of what he means by progress of invention.
Well, no, I guess, but I don't think there was no indication that he had anything very specific. I think that was on the 35,000 feet kind of view of it. How are we going to get more and better if we adopt, we have these two different perspectives to look at the issue from. Which is more appropriate if our aim is actually to, get better and more innovation?
I see. I think I'm maybe making too fine a point on something that he probably just brushed over, because it seemed that he was, when you mentioned law and economics, I said, oh, okay, so exactly what he was pointing to. But I think I understand what you're saying. It's kind of like the way he teed it up.
Right.
Thank you.
Yeah.
So with that, no questions in the queue right now. Floor is wide open. So, Professor, nothing right now. If one pops up, I'll let you know. But I'll send it back to you in case either if you have anything more to add, or if you want to wrap up a little bit early this afternoon.
I'm happy to wrap it up early. The old adage is that there's no more dangerous place to stand than between undergraduates and free food. I think that's true as well as lawyers and their weekend pre-prandials.
Okay, sounds good. Well, go ahead and close it out.
Okay. Well, no, I don't actually have. I've given my my presentation. I'd be happy to entertain questions, but I really don't have much to say. I thank everyone for taking the time to listen, and I hope some of you find the case as interesting as I do. And I'd be happy to talk with anyone individually, again, offering, what little I can in terms of specialized perspective on this, or talk with people after the decision comes down. But luckily this time of year, we won't have long to wait.
All righty. Well, thanks very much, Professor. And on behalf of the Federalist Society, I want to offer our thanks for the benefit of your valuable time and expertise today. Also to our audience for calling in, for great questions. As a reminder, be checking your emails and our website for announcements about upcoming Teleforum calls, Zoom events, and more. But until next time, everyone have a great weekend. Thanks very much for calling in. We are adjourned.
Thank you for listening to this episode of Teleforum, a podcast of the Federalist Society's practice groups. For more information about the Federalist Society, the practice groups, and to become a Federalist Society member, please visit our website at fedsoc.org.